of the written report, hoping don't make a lot of mistake and hoping you understand me. In the slide, you can see the text of criminal code, old criminal code and new criminal code in Italy. So, when we speak of blasphemy, we commonly refer to offensive or disrespectful expression towards a deity or religion. That is what in various historically determined societies corresponds to the area of the so-called sacred. Many nations around the world have blasphemy law in their penal system despite having different demographics and legal frameworks. We find blasphemy law in very different legal systems. For example, we find them in Christian states like Greece or Iceland, in Islamic states like Iraq or Egypt, in Jewish majority states like Israel, in Buddhist-centered states like Sri Lanka, or in secular states like Canada or Germany and Italy. As can be immediately noted, the variety of legal systems that incriminate conduct deemed to be detrimental to the legal good religion makes it necessary to draw a boundary of inquiry. Asking questions about the relationship between freedom of expression and punitive blasphemy law seems to me to make sense only in relation to liberal democratic orders that have evolved around the distinction and dualism between the secular and religious spheres. Where this condition does not exist, where the religious element is fully or particularly integrated with the sphere of the political, in my opinion, there is little point in investigating the problem. These are often systems in which freedom of expression is not recognized or not fully recognized, and systems in which religion is an integral part of the dynamics of public powers, as an identifying and cohesive factor of that given system even at the constitutional level. System, therefore, in which it's perfectly natural to incriminate acts harmful to religion and religious sentiment. Of course, in the system, the outcomes can be tragic, with penalties that can go as far as the death penalty, and it makes it almost impossible to create a free discussion in religious matters that is functional to bring out religious freedom together with freedom of expression. They are therefore precious tools for those regimes to suppress dissent and nip in the bud any possibility of liberal democratic evolution. I will therefore analyze the issues from the perspective of the compatibility of these kinds of law in context where freedom of expression should be guaranteed at the highest level. In the Italian case, which will be the subject of this report, is absolutely paradigmatic in order to highlight all the critical issues that this type of indictment brings. This is particularly evident if we consider two recent cases involving a famous artist and photographer. In general, it's quite surprising to see that even in liberal democratic systems, there is a great struggle to get rid of these kinds of incrimination, thus jeopardizing the resilience of the system of freedom of expression. Of course, the outcomes will not be as tragic as in systems where blasphemy leads to disproportionate punishment. But even in secularized liberal democratic system, one can be sentenced not only to the payment of fines, but also to the prison terms, as the IKEA case we analyze stands to show. And above all, the presence of that kind of incrimination makes the regime of free discussions on religious matters very uncertain, gives the possibility to public powers to put in place censorship practice, results in conformist pressures aimed at dampening any kind of critical attitude toward the religious element. In particular, it seemed to me that there is a structural difficulty in this type of incrimination. Creating criminal cases with the characteristic of taxativity and offensiveness, what one would expect from the criminal law of liberal democratic states, is very difficult when not impossible. And almost always this results in the incrimination of facts that are considered to be detrimental to the legal good religion, ending up resolving themselves into mere crimes of opinion, either already at the level of legislative formulation or at the level, anyway, of judicial interpretation. But in general, another aspect is often overlooked by this type of indictment, and that is the need for protection of the religious freedom of all equally, including therefore of non-believers who are never or almost never considered by this indictment, which almost always directly become a limit to the freedom of expression of thought of non-believers, to their rights to irreligious propaganda. All of this can be fully appreciated precisely by having regard to the Italian case, which proves to be very interesting for this kind of analysis. In Italy, there have been, for almost 50 years, criminal change based on the principle of the state religion, even if the state religion was no longer provided for in the Constitution. The permanence of the provision of the Rocco Code of 1930 and the reluctance of the Constitutional Court to take note of their unconstitutionality made the provision of equality in religious freedom and freedom of expression totally ineffective for a long time. In fact, the system was based on a privilege for the Catholic religion, which was protected by all indictment, including the vilification and blasphemy, structured as mere verbal offenses of the idea, and other religions protected by only 3 out of 5 indictments, and with the diminished punishment, as if the same behavior did not have the same disvalue if committed against a religion other than Catholic. In the first phase of its jurisprudence, the Italian Constitutional Court was very timid and uncertain before this law. The first judgment that is relevant to the analysis is 125 of 1957, which concerned Article 404 of the Criminal Code. The question arose in a criminal proceeding concerning the vilification of sacred image. The judge Equo motivated the referral by arguing that this provision was related to the principle stated in Article 1 of the Lateran Treaty, and therefore it was in conflict with the Constitution, in particular with Article 8. All denominations are equally free before the law. For the state advocacy, however, there's no conflict with Article 7 and 8, because Article 7 guaranteed the survival of Lateran pacts, even after the Constitution came into force, while Article 8 recognized equal freedom, but not the intrinsic equality between confessions. The judge further specified that this system of differentiation was based on the importance that the Catholic Church had in history and still has, based on the uninterrupted belonging of almost all of Italian people to the Catholic religion. Okay, go to the flesh. Sorry. The court preferred to accept the approach indicated by the state advocacy, making it clear that the majority criterion, the adhesion of almost the totality of the Italian people to a confession, could legitimately be the basis for possible discrimination between the confession and between individuals. The subsequent decision number 79 of 1958, concerned another provision, Article 724 of the Criminal Code. The Constitutional Court referred to the previous decision in order to arrive quickly at its decision and set out the ratio decidendi. The Catholic religion, as the religion of almost all citizens, is deserving of a particular protection under criminal law because of the greater breadth and intensity of the social reaction naturally aroused by the offense direct against it. It is therefore rejected the objection of unconstitutionality. So, it is the majority criterion that makes the discrimination between Catholics and non-Catholics constitutionally legitimate. In the second phase of its jurisprudence, the Italian Constitutional Court seemed to change orientation, but it does not draw the logical conclusions from the premise it posits. The next judgment, number 14 of 1973, again concerned Article 724 of the Criminal Code. The court judged the judgments in this decision since of change began to appear, since it's possible to discern a change of opinion in relation to the concept of a religious sentiment, which was no longer considered protected as such, but as an expression of individual freedom. The Constitution, with the recognition of the inviolable rights of man, and among them the freedom of religion, protects the religious sentiment and justifies the criminal sanction of offense caused to it. The incrimination of blasphemy, sanctioned by Article 724 of the Criminal Code, is not therefore in contrast with the constitutional rules, but on the contrary, in base of them. After the statement, however, in a contradictory manner, it confirmed its own case law, justifying the limitation of the legislative provision to offense against the Catholic religion on the basis of assessment made by the legislator of the extent of the social reaction caused by the offense against the religious sentiment of the majority of the Italian population. Finally, he put a warning in the appendix to the reasoning. However, the court believes that for a full implementation of the constitutional principle of freedom of religion, the legislature must provide for a revision of the rule, in the sense of extending the criminal protection against offense against a religion feeling of individuals belonging to denomination other than the Catholic one. In the third phase of his jurisprudence, the Italian Constitutional Court declares unconstitutional, finally, all the articles of the Criminal Code. In 1995, the Article 724 of the Criminal Code. The Constitutional Court first declared the expression state religion incompatible with the fundamental constitutional principle for the secular nature of states. And then he set the alternative between considering the case cancelled from the legal system because it was undefined, or consider it existing and referring to the Catholic religion. The abandonment of the quantitative criterion means that in matters of religion, since the number is no longer valid, the equal protection of the conscience of each person who recognizes himself in a faith, regardless of the religious denomination to which he belongs, is now required. The Card argued extensively in order to highlight all the meanings of the case examined, concluding the two essential points affirming in the most recent case law now referred to add to held firm the irrelevance of the numerical criterion in constitutional assessment in the name of religion equality, and the fact that the rule punishing blasphemy belongs to the sphere of offense relating to religion. Consequently, the constitutional parameters indicate Article 3 and 8 were pertinent, and it was necessary to draw from them the concept of declaring unconstitutional the provision punish blasphemy insofar as it differentiates the criminal protection of individual religious sentiment according to faith professed. In the 1997, it was Article 404 of the Criminal Code that came under the jurisdiction of the Constitutional Court, and the Court overruled the precedent. The reference to the so-called social conscience, if it can be valid and as an argument for the appreciation of the choices of the legislator from the point of view of their reasonableness, is vice versa, provided there were the Constitution in Article 3, paragraph 1, expressly established the prohibition of differentiated discipline on the basis of certain distinctive elements, among which is precisely religion. Otherwise reasoning, one would end up making the constitutional guarantee of equality yield to the changing and unpredictable attitude of society. If we consider, moreover, that the greater the strength of such reaction, the greater their diffusion in society, we can understand the contradiction inherent in subordinating to them the guarantee of equality, a guarantee which, with the respect to some potential factor of inequality, contributes to the protection of minorities. So, the Constitutional Court, in the third phase, declared unconstitutional all and verify the discipline. But the question of equal protection of religious sentiment, which is not part of any confessional affiliation of religious sentiment and of all other sentiment of conscience, is therefore still unresolved. With regard to the criminal protection of religious sentiment, after the work of partial cleanup of the Croce Code carried out by the Constitutional Court, in the last few years, law number 85/2006 was issued, setting out amendment to the criminal code on the subject of crimes of opinion. This measure replaced the Adeline Book 2, Title 4, Chapter 1 of the Penal Code, which now reads Crimes against Religious Denomination, and rewrote the articles on this chapter with the aim of reorganizing the sector, taking into account the partial dismantling of the provisional system by the Constitutional Court. The legislative change not only arrived too late, but also seems to be intervened without properly calibrating the intervention in relation to the court ruling. And firstly, we find as the title of chapter of offense against confession religious, denomination religious, but it was certainly not the protection of the eventual collective container of the exercise of religious freedoms constitutes the rationale for those judgments. The reference point for criminal protection is therefore the heritage of faith, doctrine, culture, custom, and civilization held by religious groups organized according to institutional model. But if that is the case, we are outside the scope of the constitutional card, which had spoken of the protection of individual religious sentiment, which should therefore also be extended to non-believers by means of criminal offenses with the following features of real offensiveness towards all individuals and their dignity. Furthermore, the polarization of protection on the basis of religious denomination reproposes all the problems of the determination of the case in view of the difficulties of definition, also in relation to the recognized system provided for in our legal system. There are problems of constitutionality from the point of view of the specific nature of the case, Article 25 of the Constitution. What is to be understood by denomination? In addition to the Catholic Church, are they those that have signed agreement with the state, those that have an organizational structure that can be recognized by the interpreter, or all possible religions? Does a Muslim or an imam fall within the scope of Article 403 of the Criminal Code? For our legal system, Islam at the moment has only a mediated recognition of the Grand Mosque of Rome. But can someone who belongs to a Muslim associated such as the UCOI, Unione delle Comunità Islamiche Italiane, for example, be a conduit for offending a confession even if the UCOI does not have this recognition? And that its imam are not therefore recognized as minister of religion. It's obvious that if we favor the restrictive interpretation of the provision, which would be required in criminal law in view of the principle of the favor libertatis, these are the first obvious problem of this unhinged regulatory intervention that took an incorrect protection reference at its basis. In addition, the persons offended should be in their capacity as believers or ministers of religion who are identified or identifiable, because that is precisely where the difference between Article 402 and Article 403 lay. The former punished, vilifying, were referring to the idea, the latter punished the same referring to the person. The second punished the same word but referring to the person. In addition, as regards the new legislation, it does not seem the legislator intervention was very well thought out. So, we don't have time. Apart from these aspects, which are far from negligible, the provision in question appear to be unconstitutional, also and above all because of the violation of the principle of equality, since there is no provision contemplating the incrimination of insulting behavior towards the person representing a religious, agnostic, philosophical strands of thought, or, for example, associations such as the Hua, thus causing discrimination between believers and non-believers that is incompatible with Articles 3 and 29 as interpreted by the Constitutional Court since decision number 117, 1979. However, it does not seem possible for the legislator to intervene in such a way as to satisfy the needs arising from the constitutional principle invoked up to now in support of the declaration of unconstitutionality of the regulation examined. The most practicable solution, the most reasonable and most in harmony with the principle of favor libertatis, from which derives the need for a criminal law as a last resort, also considering the practical difficulties inherent in the preparation of this case, as well as those in the application of the law, appears to be elimination of provision of this type from the criminal code. In one recent case appears all difficulties in the case is the case of Oliviero Toscani. The recent case involving this photographer, as for the time being ended with his acquittal. It's very interesting to analyze the divergent motivation of the tribunal which had convicted him and the Court of Appeals which acquitted him. It seemed to me that this affair demonstrates the fragility of the legal framework underlying the criminalization of offenses relating to religion. It also makes clear the danger of leaving such wide margins of interpretation of the offenses in the hands of the criminal court, which cannot fail to reverberate negatively on the extension and fullness of the freedom of expression. The facts. Oliviero Toscani, during a radio broadcast, La Zanzara, stated as in his style, which everyone can, of course, freely judge on the level of appropriateness and good manners, that for an extraterrestrial landed in Italy, the interior of a church resembled a sadomaso club, given the iconography. That the incumbent popes were the architects of a big and serious show in the beatification processes of previous popes. That in college runs by price, sexual molestation is the rule. That recommending not to use condoms in areas of high HIV density was tantamount to being murderous. That the structure of the Catholic Church was the largest sexist organization ever seen. The Court of Milan, in a ruling dated July 22, 2019, convicted Oliviero Toscani of offenses under Articles 403 and 404 of the Penal Code. This, sentencing him to a fine of euros for having offended the Catholic religion by his statement toward the vilification of two pontiffs and the crucifix. In particular, the judge emphasized that the sentences were contemptuous at the highest level and of a verbal incontinence of rare offensiveness, comparable to the propaganda language of Islamist fundamentalists, as well as gratuitous offenses. The judgment was also characterized by an uncovered Catholic extremist attitude of the judge, who continually insisted of sensing the possible subsumption in the offense of the incriminal phrase, took for granted the integration of the same without, in the least articulation, their reasoning, and superimposing his personal judgments, often totally unrelated to the judgment. No possibility for recognizing the right for criticism was present for the trial judge. Toscani's defense, in filling an apple, decisively denied the possibility of bringing the photographer's files back into the integration of the case present in the criminal code, and in any case challenged the failure to apply the exculpatory nature of the exercise of criticism. In particular, it was pointed out to the photographer merely expressed his belief on issues of enormous public importance, and that certainly his work could not be evaluated using as a yardstick the sensibilities of the individual, particularly the religious-oriented individual who has a rather low threshold for tolerance with respect to feeling offended. Already, the judgment of the Milan Court of Appeals is notable for a great interpretative rigor aimed at determining precisely the contours of the criminal offenses and verifying whether or not Toscani's phrases entered the area of the criminally prohibited. It's to be particularly saluted precisely for bringing the case back into the term that should always be proper to the criminal judge, restrictive interpretation and favor libertatis. On the alleged offensive to the crucifix that Toscany allegedly integrated with the words, "You enter in a church, you see one attached, nailed to a cross that bleeds." The court is clear. In that image, there is no vilification with insulting expression of the object of worship. There is certainly a crude reading of the mere figurative content divorced from the ultimate meaning for Christianity, but it is not possible to find in it manifestation of content. The fact, therefore, does not exist with regard to 404 Criminal Code. But it's with regard to the reconstruction of the case in Article 403 that the Court of Appeals places some very important stakes, questioning the subsumption of the photographer's words in the criminal case, obliged the judge to divest himself of his own individual sensibility, connected to the albeit respectable adherence to the Catholic religion, in order to place himself in position of secularity that allows him today to evaluate the vilification of his religion and tomorrow that of the vilification of the Hindu, Confucian or Islamic religions. Just to give example, operation with the first judge seem not have done and which, although it requires the considerable effort of temporary distancing from one's beliefs, is unfailing for those who must judge. It is ultimately matter to the principle of independence of the judiciary, which can well be read not only as freedom from political, external, or even internal condition, but also as an expression of freedom from the conditioning of one on internal forum in order to confront with the balance and equanimity in the response of justice to be given to the citizen, also with devolution or common feeling. In the light of this premise, the analysis conducted is tight and rigorous. Toscany words do not integrate the case, not so much because harsh critical and even violent tones were not used, but because topics of clear political and social impact were dealt with to discuss on which the claim of the first judge that they are the prerogative only for philosophers and theologians is frankly not shareable. And the offense lies in the generalization of the phenomenon is certainly does not constitute an offense, since it is a personal view of certain phenomena expressing in sarcastic and deliberately exaggerated tone, but not with merely despairing or gratuitous offense purpose. Therefore, it not thus appear to the sensitivity of believers can be affected by distorted and exaggerated perception of phenomena that does exist and which the intellectual honesty of Catholics themselves has been at come to terms. So, for finish, because we don't have the time for the last part. On the qualification of Wojtyła as a murderer, on the issues of condoms in Africa, the decision closed very sharply in the sense of reaffirming the breadth of the right of criticism. The undoubted violence of the criticism, in the light of the Church's position of clear ethical, social, but also political matrix, which could not go unnoticed by the laity, to whom it appeared incomprehensible, was the expression of total dissent for a vision of the values of life and sexuality prevailing in the Pope's view, even on the risk of death linked to the non-use of condoms by population with very high index to sexual promiscuity. This is a deliberately and constantly insulting expression, but one does not find in it gratuitous and disparaging criticism of the Catholic religion or the post, but a profound dissent for a position that involves social issues as well as ethical one, and which therefore cannot be, especially for alignment, the exclusive prerogative of the ecclesiastical hierarchies. In conclusion, in my opinion, it only remains to hope, in order to solve the problems we have seemed to be present regarding freedom of discussion in religious matters, that in the future the legislature will not only take note, but also legislate in the direction advocated by the Tavola Valdese in the understanding entered into with the Italian state. The Italian Republic takes note that the Tavola Valdese, in the conviction that faith does not require direct criminal protection, reaffirms the principle that criminal protection in religious matters must be implemented only through the protection of the exercise of the rights of freedom recognized and guaranteed by the Constitution, and not through the specific protection of religious sentiment. Article 4, law number 449, 1984. So thanks, and so sorry for my bad pronunciation.
Thank you very much.